Good afternoon to everyone. First of all, thank you very much, Stephanie, for your introduction. I'm very happy to be here today with you. I've been following the work of the Global Young Academy for a long time, and in particular that of the Open Science Working Group. I really appreciate your work, and I have learned a lot during this time, which is why I'm twice as happy to be here today with you. So let's start our presentation. Today I'd like to discuss with you the legal issues of open science, the legal challenges of the open science implementation. This was part of my PhD research and part of my current postdoc research project. So any feedback from you, even criticism, are welcomed, indeed encouraged, in order to improve my research. So I would be very happy to receive your point of view. My field of research, as Stephanie said, is philosophy of law, so I am particularly interested in the role of institutions in the implementation of open science. I'm trying to move my presentation. Okay. I divided my presentation in 4 sections. I'd like to start by clarifying what is meant by open science. I know that you are experts, but often during these years, I had debates on open science only to realize at the end of the discussion that the speakers, maybe in the same room, had different ideas of the same phenomenon. For this reason, I will also focus on what is meant by openness, because in order to understand the action of the legislators, the action of the policymakers, it's necessary to shed light on terminology. Then we will focus on the legal challenges, on the legal issues of open science. I will present an overview on the regime for research, data sharing, and reuse, on the issues related to intellectual property sector, and on the concerns about the privacy and the protection of personal data in the scientific research sector. These will allow us to develop some thoughts on the current governance of open science as conclusions of my presentation, and before opening the debate, the discussion with you. Just a disclaimer, my perspective is European, mainly. I have analyzed the European legal framework and its considerable developments during these years. I'm currently trying to, let's say, to broaden the scope of my investigation. Because inevitably scientific research can and do cross geographical boundaries, and also increasingly the challenges of our time, I think, require us to work globally. I'm therefore very interested in your views on different legal frameworks. It's very relevant to discuss the resilience and also the flexibility, the ability to adapt of the various and different traditional legal systems. Okay, so let's start with the introduction, so about the evolution of the concept of open science and the EU approach. When we think about the origin of open science, first of all, we have to look back about 20 years ago to the early 2000s, when the open access movement started and gain momentum. Think about, for example, the Budapest Open Access Initiative of 2001, or the Berlin Declaration on Open Access to Knowledge in Sciences and Humanities, or also the Bethesda Statement on Open Access Publishing. here at that point, we were at the beginning of 2000s. It's only about 20 years ago, but it seems an entirely different world. The web had just been established. The potential and the advantages for scientific research were incredible, and to some extent also disruptive. Originally, open science meant open access. And the open access movement was represented by a small group, a small part of the scientific community, almost pioneers, groundbreakers. The initial efforts of the open access movement, the scientific literature, so papers, scientific papers. Peter Suber from the Berkman Klein Center of the Harvard University pointed out that having an open access scientific literature means having a scientific literature that is digital, online, free of charge, and free of most copyright and licensing restrictions. But what has happened in these 20 years? Well, as you can see from my slide, almost all kinds of things happened. From open science being merely and exclusively synonym with open access to scientific publications, over time, open science became many things at once. And what do I want to suggest with these bubbles here in the slides? That indeed for a while, open science was these many bubbles. Phenomena, not necessarily connected to each other. Indeed, often each of these phenomena was the result of disconnected and inconsistent efforts, even within the same university or the same research center. So open science was related to the openness of research data, but also to infrastructures or to the sharing of methodologies or laboratory notebooks or whatever. But open science also represented the involvement of civil society, but also the institutional projects. For example, here the European Open Science Cloud. Open science also represented the niche phenomena, such as crowdfunding of science. I've written a paper about the phenomenon of crowdfunding of science, which you will find in the link at the end of this presentation in case you are interested in. So what is open science today? Well, I would say that it is all of these all together. We can define the openness, the open science approach in a more coherent way as the openness of every phase of the scientific research cycle. Within each phase, takes a different meaning. In other words, we can say that the open science approach is synonymous with a good science, which is based on communication, cooperation, that wants to avoid the waste of efforts, a science that is transparent and is also able to take full advantage from the use of new technologies, minimizing the risks related to the use of these technologies. Of course, we are not talking about a blind and indiscriminate openness, but an openness that follows the formula as open as possible, as closed as necessary. At a certain point, indeed, we could say that open science became, to some extent, institutionalized. Open science transformed itself from being instances brought forward by one part of the scientific community. Open science became something else. This in the slide is an excerpt from a website of the European Union from 2015. about the digital single market. And in this slide, you can find the definition of open science as an approach that wanted to transform science through digital tools and networks to make research more open, global, collaborative, creative, and closer to society. The interest of European institutions in open science has been remarkable in these last years. Part of my doctoral research, which you can find in open access, of course, if you are interested in. So part of my doctoral thesis was to map out the European framework, starting in 2000 with the identification of the fifth European freedom, the freedom of free movement of knowledge and researchers, up to the present day, in particular to the new European research funding program, which is called Horizon Europe, replacing the previous one. Maybe you are very familiar with it, the Horizon 2020 program. There is a lot of information in this slide. If there is any aspect that interests you specifically, I'm happy to discuss it with you at the end. At this point, we need to wonder about what does openness in science mean? Because as I said, in defining the open science as a process, the notion of openness in relation to different phases of the scientific research process changes. Apparently, it would seem peaceful and devoid of any tension to want to open up scientific research, to share with citizens results, and so on and so forth. And it's also in line with democratic values. But the difficulties in implementing the open science that are emerging right now show us that it is not so easy, that there is a layer of difficulties. So I believe that openness can take on three meanings, and from each of these, different principles are derived. Originally, if we look at the early development of open science as the open access movement, openness was a possibility. Why? Well, because new technologies provided a number of unprecedented advantages that were completely overwhelming the original way, the traditional way of doing research, of doing science. Think about the dematerialization of papers and the new role of libraries as repositories instead of material place. So the related principles were access and collaboration. Immediately doing research by collaborating between geographically distant centers became easy, if not the routine. After, a new interpretation of openness has drawn up. Openness as an institutional answer, an institutional response to different needs. Which needs? Well, first of all, the needs representing the instances of the part of the scientific community that advanced the open science movement, that advocated the open science movement. And then also the needs of companies and the business sector that demanded a data-driven economy, and to some extent was related to a data-driven science. In this period, open science adopted the principle of transparency, the principle of sharing, which became a real imperative, and the principle of integrity. Open science became a way to face the reproducibility crisis of science, for example. In other words, open science became a matter of integrity. But something is missing. And we are recognizing it right now during this current phase of implementation of open science. In my analysis, I was helped by Sabina Leonelli, a philosopher of science and also an alumni of the Global Young Academy, so I think you know her very well. In her new book, just out these days, like yesterday or today, she provides a philosophical framework for open science and stresses the need to avoid, to limit, to reduce the phenomenon of open science just to sharing. This would entail what she called a condition of epistemic risk. So reducing open science as a matter of sharing any kind of materials that can be data or papers or laboratory notebooks or whatever, may generate an epistemic risk. And this epistemic risk has two consequences. First of all, it can result in the exclusion from sharing initiatives of researchers who are not based in prestigious universities able to implement open science initiatives and support costs of the implementation of open science initiatives. And two, it reduces the diversity and the range of data available and also the type of expertise perceived as significant. Specifically related to the evaluation process, so perceived as significant when evaluating the scientific research. This is why another dimension of openness as pluralism must be taken into account. The principle of inclusivity and the principle of equality derived from it. What does it mean? It means that the openness of science must absolutely take into account the peculiarities of different research fields, the specificities of different areas of the world, and also of different starting conditions. Otherwise, opening up science only in the first two meanings, so openness as possibility and openness as answer, response, institutional response, risks amplifying the previous existent injustice, becoming a means of increasing inequalities and centralizing knowledge and power instead of decentralizing it and actually share it. These three dimensions must be borne in mind when approaching the analysis of legal issues of open science, which is time to analyze. Well, clarified what is meant by openness, what about the legal framework? Well, we have a very legal framework concerning the scientific research sector. Why is it so complex? Well, first of all, consider, for instance, that right now, just looking at the research data, at the data in general, at European level, we can count 18 normative acts, 18 legal acts concerning data already approved or sorry, I was looking at the chat, already approved or just proposed. Here in the slide, I proposed three examples. The first one is the directive number 1024 of 2019 about the open data and the reuse of public sector information, but I will say something more about this directive later on. There's also very relevant a new regulation from 2022, number 868, the so-called Data Governance Act, in which we can find the definition of the concept of altruism of data that will have a huge impact on scientific research. And here, another example is represented by a proposal, which is a proposal of the regulation about the Artificial Intelligence Act. And we should not forget that for scientific research sector, the European Union, according to Article 167 of the Treaty of the Functioning of the European Union, has only a support and coordination role. Why? Well, because in this specific area, based on the separation, on the division of competencies between the European Union and the member states, the member states have a considerable leeway and flexibility in the regulation of the scientific research sector. An emblematic example is represented by the GDPR, which is the General Data Protection Regulation, the European regulation on data protection. The GDPR is a regulation. As such, it provides a unique framework, legal framework for the processing of personal data in the European Union at European level for every member state, except for a few matters in which there is a space for national regulation. Scientific research is one of these matters in which there is a space for national regulation. Therefore, we can say that we have a disciplinary stratification or fragmentation, which is an element of complexity. To deepen this complexity, to better understand it, let's take the case of the research data. Just considering the management of research data, three major concerns arise. First of all, issues related to the identification of the legal regime for sharing and reusing research data within the EU open data framework. As I said, openness may be represented as the institutional answer. In that context, the first one, here we are, openness became a synonym with sharing and reuse. So what the regime for that openness? Which kind of implications does it have? Then we have challenges related to the intellectual property legislation. And finally, a tension between openness and personal data protection, namely GDPR and national legislations, can be envisaged. One of the fundamental dimensions of open science is the openness of research data. First of all, what is meant by research data? Basically, it's not that research data are different from other data. They may be distinguished on the basis of these three elements, these three aspects, these three features that are represented by the purpose. So data that are used for scientific research purposes, that are part of a process of analysis that is traditionally identified as scientific method, and are data that are a means to enable the reproducibility of experiments in order to ensure the review, the peer review, the so-called peer review, the review of the research output by the scientific community. If the objective of openness is openness in relation to the research data, the institutions, the European institutions, identify openness as sharing and reuse of research data. But I think there is an aspect that comes before sharing and reuse, and without this preliminary essential aspect, one can neither share nor reuse such data. That is the good research data management, the good technical management of research data. Let's look at the standpoint of the European lawmaker on the legal regime for research data sharing, and thus try to understand how to ensure a good technical management of these data. A new directive, as I mentioned before, on the sharing and reuse of public sector information was issued in 2019 to be transposed by each member state by July 2021. The news here is that for the first time, research data are also included in the scope of application of the directive on the use of public sector data, so the so-called open data. In fact, Article 10 of the Open Data Directive is precisely titled Research Data, is precisely devoted to research data. And it tells us quite a lot in this respect. There are some aspects to consider about the research data sharing regime as developed by the EU institutions. The required national transposition, first of all, is not a mere act of internal transposition. It's a real mandate for member states to design national strategies and policies. The Article 10 states that member states shall support the availability of research data by adopting national policies and relevant actions, aiming at making publicly funded research data openly available. And consider the fact that the choice of the legal instrument of the directive is understandable on the one hand because it fits with the sharing and reuse of open data of the public sector, not with research data. And on the other hand, because the division of competencies between EU and member states that I mentioned before are another reason why the directive could be a suitable legal instrument. But it's also true that having legislation on a legal basis related to the sharing of research data leads to a fragmentation of the European legal framework. And very often research projects are developed between member states or often with countries outside the European Union, of course. Then consider the fact that Article 10 of the directive states the clause of openness by default. It means that the openness in terms of sharing and reuse becomes the rule and the closure the exception. But I think that in order to ensure the enforceability of such openness by default, one must also act on the awareness, on the education of researchers themselves, making them understand the value of sharing and the risks sometimes of the openness. So the balancing act between openness and closure. In addition, Article 10 also mentioned the fair data principles. I think you're familiar with the concept of the fair data principles. However, I want to spend 2 words on this notion because the mention of these principles in a hard law legislation is relevant. It's the first time and it's related to the 3 interpretation of openness presented some minutes ago in the second part of my presentation. I think that the fair data principles are a way to link the notion of the openness of research in terms of sharing and reusing research data and the concept of good research data management. Many operations can be required to have good technical data management. The adoption of the fair data principle is not the guarantee or the only way to safeguard, to guarantee a good research data management. I think that the idea was to have a common basis in the data management, in the research data management, which cuts across research subjects and different fields of research. The fair data principles are not a standard, are just guidelines. These principles were first formulated in the paper that I mentioned in the slide from Wilkinson et al. In 2016. FAIR indicates an acronym that stands for findability, accessibility, interoperability, and reusability. And these are characteristics that research data must have in order to ensure a good management of research data. For each of these characteristics, a set of operations are then identified in order to implement them. And as I said, they are guidelines, not standards. So this is why they need to be adapted to each individual research sector. Another much debated and discussed topic is the one related to the area of intellectual property. This topic interfaces in many different ways the various phases of the scientific research process and the concept of authorship of ideas. From the perspective of publications, so monographies, books, papers, I recommend a recent book written by Professor John Wilinski, which analyzes the topic of academic copyright from the perspective of US law. Concerning the European Union, in December 2022, a recommendation of the Council of the European Union, which was the number 2415 on guiding principles for use of knowledge, has been released. A relevant novelty is the reference to the open science in the management of intellectual property, stating the need to increase awareness and uptake of intellectual asset management practices and tools in open science, as well as in open innovation to facilitate the use of results and data for innovation. It's however admitted that many notes remain to be entangled regarding scientific research data. Data per se can hardly be covered by copyright. In fact, copyright protects the so-called creative work and therefore does not protect neither ideas nor facts, mere facts, which always remain in the public domain. Research data can obtain the protection to the extent that they are aggregated in databases, namely collections of works or data that are systematically or methodically arranged and that are individually accessible by electronic means. Such collections of data, such databases, may be protected by copyright if they represent the result of a creative effort, thus being identified as an original work of creativity. Furthermore, there is also the Directive number 9 of 1996 of the European Union that refers to the so-called sui generis right, as the right held by the creator of the database, of the non-original databases, in case the creator is able to prove he or she made an investment, a concrete investment in the creation of the database itself. These form of protection, namely copyright and the sui generis right, are not mutually exclusive. Copyright prohibits the reuse of research data, of data in general, and the sui generis right prohibits a qualitative or quantitative, but also a substantial or total extraction of the contents from the database. The problem, I think, is that the intellectual property issues in the university context or in the research context, let's say, are often dealt with by actors who do not have the expertise to do so. This results in the fact that academic researchers often believe that they are the owners of the data they collected or they created during their research. This position stems from the idea that data and databases can be subjected to copyright, and that therefore researchers are the legitimate owners because they created these databases and these data or collected these data. However, the university or the research center may actually own the database. In contrast, the sui generis right is attributed to the maker of the database, so the creator, according to the recital 41 of the Directive 9 from 1996 of the European Union. So you can understand that given this complex framework of legal uncertainty, contracts plays an increasingly relevant role. Nowadays, research projects often involve public and private actors, and this leads to power asymmetries in constructing, in defining these agreements between actors. Then a further interesting aspect is represented by the text and data mining techniques and the application of text and data mining techniques for scientific research purposes. Because the application of text and data mining techniques for scientific research purposes may entail an infringement of the copyright or of the sui generis right, protecting the work or the database on which these techniques are performed. The 2019 Copyright Directive of the European Union provides for some exemptions, specifically for research and teaching activities, but these exceptions, these derogations are not binding, but are left to the legislation of the member state, so to the national level. You can see that this creates a system that on the one hand intends to foster, to enhance open science, and on the other hand strengthens the intellectual property legislation. Then what about the privacy and data protection issues? Well, attention must be drawn now to the legal framework built for the processing of personal data for scientific research purposes. That is represented by the GDPR, as I already mentioned it a couple of times. These regulations, so the Regulation 679 of 2016, the General Data Protection Regulation, its national and adaptation legislations, and recently, big news, the new adequacy decision by the European Commission on personal data transfers between the European Union and the United States has been approved, underpinning the data privacy framework. It's very recent, from July 2023, last month, and it certainly has impacts on scientific research. These three elements, so GDPR, national legislations, and also agreements for transfer of personal data outside the European Union for scientific research purposes, make the processing of personal data for research particularly complex once again. Here in this slide, I wanted to provide you an overview on three of the most problematic issues when processing personal data of data subjects, namely individuals involved taking part in the research projects according to the legal framework I showed in the previous slide. So GDPR, national legislations, and adequacy agreement. Multiple issues arise in defining the correct or the most suitable legal basis on which researchers may legitimately process personal data for their research project. A further element of tension between scientific research and specifically open science and the EU legal framework is represented by the principle of data minimization. According to the principle of data minimization, the personal data shall be adequate, relevant, and limited to what is necessary in relation to the purposes for which they are processed. You will understand that in the case of scientific research in general, but even more in the case of exploratory research or in the context of open science, it is difficult to actually minimize the data available for a project. Finally, as anticipated, a third challenge is represented by the transfers of personal data outside the European Union. The gap I mentioned here in the slide has been filled right now by the recent adequacy decision that I mentioned before. It remains to be seen which kind of implications this decision will have for research sector. I realize that I'm communicating a lot of information. If there is some aspect that you are particularly interested in, we can discuss it further later, or you can send me an email. I'm always more than happy to discuss concrete cases with researchers that actually process data. I'm a lawyer, I do not process data, so I'm always very interested on these aspects. And I inform you that in a couple of weeks, a special issue on open science and data protection that I edited for the Journal of Open Access to Law, the JOAL journal, will be published. So this special issue will be fully and freely accessible, of course. And it consists of a large number of contributions. This table is just a sort of summary of some elements of this special issue, which is an interdisciplinary special issue with a lot of different, a lot of authors with different backgrounds, mainly legal, but the goal was to identify a bridge between the legal issues, specifically data protection legal issues, and other disciplines, other branches of the research sector. Okay. To sum up, in conclusion of my analysis, as I said, I focused on the EU level, which apparently seems to be well established in the open science implementation, considering the institutional involvement, the commitment, the development. Yet, I found a considerable lack in terms of coordination between the different levels, so the European level, the national level, and also the local level, where by local level, I mean the level of individual university and specific individual research center. The efforts are there, but especially at local level, there is little coordination. Yet the legal issues are the same from university to university. So I believe that there are aspects of open science where it's not only important, but it's really vital. It's essential to preserve the peculiarity, to let's say, to protect, even enhance the specificities of specific conditions, in line with the principle of inclusivity, in line with the principle of equality at the basis of the open science approach. But from a legal point of view, more coordination is essential, precisely to the extent that the problems are the same in each university or research centers, because the legal system, the legal framework, at least, is the same. There are many reasons why there are still difficulties in achieving a greater openness in the scientific research sector, in the scientific research process, that are cultural, that are ethical, that are economical, and so on and so forth. I believe that there is also a problem at the level of the governance. Over the years, for example, there have been multiple initiatives, perhaps at local level, disjointed and disconnected, not coordinated, which have dispersed efforts. The self-regulation approach failed to some extent because introducing open science through policies or university guidelines often resulted in a lack of enforceability. A top-down approach by institutions is not feasible either at the European level or at national level. At European level is not a viable solution due to the separation of competencies between EU level and national institutions, as I said before. And in the second case, so a top-down intervention by national institutions, in that case, there's always the limitation of the autonomy of the scientific community, represented by the academic freedom ensured in Article 13 of the Charter of Fundamental Rights of the European Union. And the intrinsic need for cooperation with the multiplicity of different actors doesn't fit well with the top-down approach. I think a more suitable approach seems to be the co-regulative model, which envisages the participation of all actors involved, emphasizing what the philosopher of law Norberto Bobbio called the promotional function of the law. I would like then to conclude my presentation with two pieces of news, quite recent, announced within 6 months of each other. The first one, NASA and the major US research centers announced in January 2023 that the year 2023 would have been the year of open science. In June, so 6 months later, it was announced that all non-US partners in NIH-funded research projects must submit regular data and lab notes to the NIH. So these two elements clearly, I believe, clearly underline the interplay between science, technology, and law and institutions, and clearly identify how crucial it is to wonder which kind of openness we want to pursue. Thank you very much. I finished my presentation. I hope we have time to discuss a little bit.
Thank you so much, Ludwika. That was very insightful. A lot of things I hadn't thought about before. But we definitely have some time for questions. We have about 11 minutes. I'm Tasha. I'm Sept's co-lead for the Open Science Working Group, and just stepping in because Sept is in a loud airport right now with some children running by. So we did have a question in the chat, and we had some responses to this question already from the crowd. But in your opinion, is open access via APC payments a positive or negative development?
Well, of course, it's a very negative development. I don't think that changing the system, introducing APCs is a way to, it's a matter of open science. When I identified the three meanings of openness as a possibility, as institutional answer, but also as pluralism, it's clear, it's crystal clear the fact that the principles related to these three interpretations of openness don't have anything in common with a system in which you have to pay to publish. I mean, the APC's system shift the amount of money paid from the reader, so let's say the citizen, or the scientist from this university that doesn't have a specific subscription to a specific journal, to the author. I absolutely don't think that it's not even open access, let's say. Open access is something different. So I don't know if my answer is sufficiently.
No, I think that's good. I'm guessing most people in the room had an idea of how you might feel about that, but it's still good to address and hear kind of your thoughts on it. So with that, we can open up. There's a comment also from Hans in the chat.
I lost you. I wasn't able to listen to your last sentences.
Can you hear me now?
Yes.
Okay. There's also a comment in the chat about looking for international frameworks on open science, UNESCO, but other than that, there are no questions in the chat. So I would love to open it up for questions, either more in the chat, or you know, if you have a question, you can go ahead and use the raise your hand in the reactions. So there is another question. How do you think open access should be financed if you don't think APC is the right model?
Call the author space change. I know the UNESCO recommendation on open science. I follow the process that lead to the adoption of this UNESCO recommendation. And the one important aspect of the UNESCO recommendation on open science is the fact that UNESCO and the other entities, international entities involved in the production of this recommendation focus the attention also on the peculiarities, the territorial peculiarities and the specificities of different areas of the world, and so also the different scientific research systems of the world. So this is one of the aspects that I think are most relevant of the UNESCO recommendation. And for sure is one of the elements at international level fundamental in the identification of the framework, of the legal framework of open science. About the question, so how do you think that open access should be financed? Well, I'm not an economist. There are a lot of alternative models, and I don't want to be an extremist. I can see the relevance of a scientific journal, and to some extent I can also understand that if a scientific journal is a prestigious one, as a researcher I want to participate in the debate this journal is identifying. So I don't want to be too extreme in the analysis. But on the other hand, it doesn't. Right now, we have a system that doesn't work, so we need to find another system. About the financing the system, I don't know if I'm able to answer your question. But if you want to discuss, if you have something in mind and you want to talk to discuss with me, send me an email, send me more information on that. I would be very interested in knowing your point of view.
And Martin posted in the chat about the funding model of arXiv. If anyone's interested, said it might have some interesting things to look at there. Thank you, Martin. There was another question and someone liked it, so we have a follow-up that another person's also interested regarding the open licensed IP that fully or partially lies under copyright law. Can you elaborate on the interplay between open source and export control issues?
I was wondering if you can elaborate a little bit your question, Vladimir, because do you refer to the open source of the softwares involved used to analyze data sets? I would like to have some more information on that.
Yeah, sure. Can you hear me?
Yes.
Yeah, great. So yeah, I mean, I'm an innovation manager in open transfer, and our question is always, let's say we have a software or a hardware design, which lies under copyright law, because the documentation or the software is a copyright, and then people want to publish it, but then let's say when you publish it, that basically means under the open source license, that basically means that we license it to everyone in the world. And then that might bring some problems because sometimes we can't really license.
I lost you for a couple of seconds, so I was able to listen to your explanation at the end. Just a question about the concept of export control issues. What do you mean for
let's say we have some IP and this is not published, but then we want to.
I can't hear you.
You can't hear.
Can you? I'm losing you. Can you repeat it?
Okay.
I'm not listening. I don't know if it's my.
Okay.
Oh, it looks like we might have lost Ludovica. I think maybe her internet was unstable. Oh, and we're back. We lost you for a second. Can you hear me? You're muted. I'm gonna unmute you.
Sorry, I wasn't able to face the technological issue. You were defining the control issue.
Yeah, export control. So basically we have the IP, and then let's say it's not open sourced, and then we want to give this IP to someone. In this regard, what usually we have is that we have a licensing agreement with another party. And then that basically means that we have to go to the export control regulations if they tell us that we can't really do it. And then when we do something openly, that basically means that we license it to everyone. And then we need the procedure for that.
I can see your point. I don't know which kind of licensing system you usually adopt. For example, with Creative Commons, you have different, let's say, possibilities. Adopting a Creative Commons license doesn't mean to basically open your software to an indiscriminate or blind use. You can, let's say, modify, try to find, I don't know, identify the fact that you don't want to, the fact that someone use your software for commercial purposes, or that, or you can link your software with a specific license that needs to be follow the chain of sharing. So
I mean,
maybe
usually it lies under the problem of the dual use of the IP. I mean, let's say we have the drawing of the drone, and then the drone can either make a movie recording, or it can deliver some TNT. So basically those kind of issues. And then when we come to specific type of the IP, sometimes we can't really share it with another country, let's say.
I can see your point. I think there is a lack in the European legal framework related to specifically to copyright for the scientific research sector, what Roberto Caso called academic copyright. I can see the link to the Creative Commons licenses in the slides in the chat. I'm not an expert in IP law, but I can see the limits of these of the current situation. Maybe, I don't know, it depends also on the support. Do you work for a university?
Yep.
And do you have a team supporting you in these legal matters related to?
Yes, I mean, we're trying to elaborate all of those things because they're quite new.
Okay, because I mean, it's also, I think, having someone helping researchers dealing with these legal issues, it's a part of the data stewardship. The data steward of the university, in my opinion, should also have obviously a knowledge about the topic, the specific sector, and also the knowledge of technical issues, but also legal issues, in order to be able to be specialized for the specific needs of the team of researchers.
Okay. Thanks. I'll try to give the rooms to someone else.
I'm sorry if I was not so satisfying my answer, but if you have some specific aspects that you want to send me an email, and we can discuss.
Yeah, thank you.
I want to be respectful of everyone's time. It is the end of the hour. So I see another question in the chat from Martin. Ludovica, do you mind addressing this one question? And then maybe if others have more questions, they can send you an email.
Yes. The question, you refer to the question of Martin Domin. we see increasing concerns about collaboration with China. How do we avoid the global fragmentation in science? It's a very good question, and also a tricky one, because for sure science doesn't have geographical boundaries, ontologically speaking. But of course, there are some issues, some geopolitical issues that we need to take into account. In the special issue I mentioned before, there is also an interesting paper of Luc Sautet, Professor Luc Sautet and Bergelman from the VUB in Brussels, dealing with the concept of technological sovereignty and open science, which to some extent is something related to your question, if I'm not wrong. It's a difficult question. I don't know if I have an answer. It's something that the open science governance needs to address if we consider open science as this approach to have a good science without borders and able to share knowledge as much as possible. So
thank you so much, Ludwika. Can we have another round of applause, virtual round of applause? And again, thank you for offering to answer questions over email. Ludwika's email's up on the screen. So please, if you do have questions,